Ohio legislators want to take a foreign trip abroad, a nice trip, a five-star hotel, gala dinners, meetings with foreign government officials, and they need you, the Ohio taxpayer, to pay for it. So they wrote a bill, a trade and innovation partnership. Ohio taxpayers will pay for necessary and actual costs. No cap, no ceiling, no limit. If that were just wasteful, that would be one thing. But what they are describing is not a trade mission. What they are describing is a constitutional violation. And the Supreme Court has already said so. The partnership, with only one country driving the dialogue, it's Israel. And this is not about whether or not you support Israel. This is not about the war. No matter where you stand, this is a constitutional problem. And the courts have already ruled on it. 85 years of Supreme Court precedent, all pointing to the same direction, to Columbus. The state of Ohio does not have foreign policy. Article 6 of the Constitution, the Supremacy Clause, says federal law and federal foreign policy are the supreme law of the land. And Article 1, Section 10 explicitly prohibits states from entering into treaties, alliances, or formal agreements with foreign nations and foreign powers. This is not a gray area. The federal government decides this, not Columbus. And in 1941, the Supreme Court said it plainly in Hines versus Davidowitz. The federal government holds full and exclusive responsibility for the conduct of affairs with foreign sovereignties. Full and exclusive. What's alarming, in June of 2025, Israel launched a surprise attack on Iranian military, and the United States joined in June. We decimated their nuclear facilities, according to a report. The ceasefire was reached on June 24th. Now, 9 months later, the United States and Israel launched a second, far larger military operation against Iran. Today is day 21 of that active war. The President, the State Department, the Pentagon, they are managing one of the most dangerous military and diplomatic situations in modern American history. Right now, today, as you watch this, while bombs are still falling, Ohio is moving to formalize a permanent bilateral partnership with one of the combatants, not the United States, Ohio. In 1968, Zhernig versus Miller, the Supreme Court struck down a state law for intruding into foreign affairs, even though it didn't conflict with any other specific federal law. The court said intruding into this field was enough. And then the court said something Ohio legislators need to hear loud and clear. Resolution of so fundamental a constitutional issue cannot vary from day to day with the shifting winds of the State Department. Ohio cannot hide behind the fact that Washington hasn't formally objected yet. Zhernig already closed that door in 1968. Then in 2000, Crosby versus National Foreign Trade Council, the Supreme Court voted 9-0 to strike down a Massachusetts law that barred state agencies from doing business with Myanmar. Ohio passed a law barring state agencies from doing business with companies that boycott Israel. This is the same structure, the same mechanism, the same constitutional problem. 9 justices, 0 dissents. And in 2003, Garamendi, the court ruled that even presidential executive agreements, not just formal treaties, preempt conflicting state laws. The United States has active military coordination and diplomatic frameworks involving Israel and Iran right now, today, on day 21 of an active war. Ohio is walking directly into all of it. Ohio Treasurer Robert Sprague has purchased $357 million in Israel bonds with Ohio, public funds, since 2019. How many other foreign countries has Ohio bought bonds with? Germany? No. Japan? No. Canada? No. 0. Because Ohio law was made so that Israel is the only foreign sovereign whose debt Ohio taxpayers can fund. Ohio didn't just invest heavily in one country. Ohio encoded a foreign policy alliance into state statute. And those bonds, since then, have been downgraded by Standard & Poor's, Moody's, and Fitch. And now why wouldn't we be investing in Ohio businesses instead of a foreign country? I'm running for Lieutenant Governor of Ohio, and I need to tell you this. House Bill 188 requires the Lieutenant Governor of Ohio to be a member of this commission. If this bill passes and I am elected Lieutenant Governor, Ohio state law would require me personally to sit on a foreign policy commission dedicated to a foreign government that is currently engaged in an active war with the United States, fighting alongside of them. I would be legally required to participate in the exact foreign policy apparatus that the Supreme Court has repeatedly ruled states are not allowed to participate in. That is not a political conflict. That is a constitutional emergency. And it is precisely why I am standing here today telling you this has to stop. So if you'd like to support a candidate that supports the Constitution, vote on May 5th for Casey Putsch for governor and Kim Georgeton for lieutenant governor. You can still get registered by April 6th. We look forward to serving you.